Kohberger, on or about November 13th of 2022, in Latah County, state of Idaho, did unlawfully enter a residence with the intent to commit the felony crime of murder. The maximum penalty for this offense is death or imprisonment for life.
It's obviously an emotional time for the family, seeing the defendant for the first time.
It's usually pretty quiet. You know, we usually don't have anything like this going on in this Poconos. It's just surprising that, you know, we shop, we go to the stores here, and this person was among us.
We've got a big development in the Idaho student's murder case tonight, and it involves the preliminary hearing, which is scheduled for the end of June. This is the hearing where the prosecution has to put up enough evidence to demonstrate probable cause to a judge to bind this case over for a trial. Now, in the state of Idaho, the defense is permitted. They may present witnesses on their behalf, and they want to. And one of the witnesses that they want to call is one of the surviving roommates. Take a look. This was a motion. Bryan, the accused killer, by and through his attorney, Ann C. Taylor, public defender, moves this court for a certificate to assist in securing the attendance of Bethany Funke as a witness on behalf of the defendant in this case. During the course of my investigation, it became known to me that Bethany Funke has information material to the charges against the accused killer. Portions of the information Ms. Funke has is exculpatory to the defendant. Ms. Funke's information is unique to her experiences and cannot be provided by another witness. Bethany Funke resides in the state of Nevada, and it's necessary to subpoena this witness because the witness's testimony is material and necessary to the state. Wow, so what is it what is the information that is exculpatory to the defendant that one of the roommates has? Or at least the defense believes they have. Well, she doesn't want to testify. She has an attorney fighting this subpoena. Take a look. This affidavit in support of motion for out-of-state service claims that Ms. Funke has information. Excuse me? Yeah, Ms. Funke has is exculpatory to the defendant. These statements are conclusory, without support, and there's no further information or detail pertaining to the substance of the testimony, its materiality, or the alleged exculpatory information of Ms. Funke, or why it would be entertained at a preliminary hearing. There is no authority for an Idaho criminal defendant to summon a Nevada witness to an Idaho matter without a hearing. And there's no authority to summon a Nevada witness to an Idaho matter without a Nevada judge making a finding of materiality, necessity, and the lack of undue hardship. As this court is well aware, a preliminary hearing is limited to a finding of probable cause rather than reasonable doubt, which is the evidentiary burden at trial. Even if Ms. Funke possesses exculpatory evidence, which remains unknown, there is no place or reason to present that evidence at a preliminary hearing. A preliminary hearing requires the state to offer competent evidence to support probable cause and convince the magistrate that a trial should be held, not the issue of innocence or guilt of the defendant. What's going to happen here? How significant is this development? Let's bring back in our think tank, Ann Bremner, Rick King, and the professor, Michael Sterling. Michael, what are your thoughts here? So they're trying to get the defense. This is unusual, right? The defense is trying to subpoena an out-of-state witness with exculpatory evidence for the prelim.
Yeah, I mean, and typically, just for the audience's purposes, preliminary hearings are very limited in scope. There's a lot of hearsay that's allowed, things that happen at preliminary hearings. Oftentimes, they're waived by defense attorneys, and you just, you waive them, you enter a plea, you just sort of accept that it's going to be a probable cause finding. And so to the extent that she has exculpatory information, I disagree with Ms. Funke's attorney. To the degree she has exculpatory information, it could be material to a preliminary hearing if it negates the probable cause finding. So if there is some evidence or some information which we all know that Ms. Funke was one of the key eyewitnesses who came face to face with the killer and who have a very detailed description of what the killer looked like. If she has information that is exculpatory and could negate the finding of probable cause, then her testimony at prelim could be material, and she could be ultimately summoned to court.
Rick King, how big of a development is this? I hear the words exculpatory, and as a former prosecutor, I always get palms get a little sweaty at that moment, right? It's a powerful word.
Exculpatory is a powerful word, and we don't have those type of hearings here. But you know, I actually agree with the professor in the sense that, and I say that with respect and admiration. I agree that if there's some evidence that appears to be exculpatory and it somehow undermines the presence of probable cause, I think it would be admissible and necessary for them to present it at this hearing. What I don't understand, or what I think is problematic, is that if they filed a motion to get her there and they talk about this information that she has, why didn't they put it in their motion so that the judge could make a ruling to understand exactly what they had? And I think that's what's problematic.
They're a little bit vague about what this exculpatory evidence is. And Bremner, do you think that's because it maybe doesn't exist, or are they like they want to surprise someone with it? I don't understand why you don't lay out what this potentially exculpatory evidence actually is.
Well, exactly. I mean, is it in recognition versus description? I mean, has she looked at a montage or lineup of, can she identify him? We don't know any of those things. The other thing is, like, on bringing her here, bringing her to Idaho, I mean, they've got a lot of arguments to make that she would be, it would be unduly burdensome to her, to go to a different state. But look at all the publicity and everything else for her to have to come in and testify on his behalf in a case where all of her best friends were murdered, and when they're not even, it's a completely vanilla, declaration. It doesn't have any information. Does she even know what the information is that they're going to try and elicit from her? I did represent a witness once who I resisted going to another state in a criminal case, and we went through a full hearing. I mean, she was feeling threatened by the guy that wanted to bring her to court. And we basically gave all of the crazy letters that he wrote to her and the kind of threatening verbiage and things he wrote to her before a judge up here in Seattle, and she did not have to go to Oregon to testify. And so I kind of looked at it like that. I mean, like, she's got, I think, a good lawyer, and I think she should resist it unless there's something she can really add to the defense, which she probably doesn't want to do.
No, she doesn't want to do it. Well, we shall see how all this is going to play out, because this is significant. It looks like the defense is not thrown in the towel at all. They're fighting this at the preliminary hearing stage. Take a look, folks. It's all happening June 26th, Idaho versus the accused killer. Of course, wall-to-wall, gavel-to-gavel coverage right here on your front row seat to justice.